Why wouldn't these, I'll start with you on it, Phil, be made public? Why aren't we entitled to see the jury instructions? This is our courtroom. This judge works for us. And this proceeding is public. This isn't a secret what the jury's going to be instructed. Why don't we get to see it?
Well, great to be with you again, as always, Megan. Look, you only think he works for us. He works for his own interests, apparently. The jury charges, as you mentioned, are very critical because this is the instructions the jury will have with them in the jury room when they're trying to figure out what in the world. I can't even figure out exactly what the state's theory of the case is, but this man, and I'm speaking of Merchan here, he has shown every step of the way, in my view, that he's literally standing on the scales, tipping it in favor of Alvin Bragg. I don't expect that he's going to release the jury charges. He doesn't have to. He has to give them to the parties, of course, and they can suggest last-minute revisions and edits. But unless we get it from any of the lawyers on the case, I am not going to hold my breath waiting on Merchan to allow any more sunshine to get into this case. Sunshine being the best disinfectant because the whole thing reeks right now. He's going to keep this as non-transparent as he possibly can so that the public is going to be left in the dark, I'm afraid.
What could be more important, Andy, right? This is it. The whole case comes down to how he instructs the jury, and as I said, the verdict form that walks them through exactly what they're going to have to answer.
Well, nothing could be more important, Megan, but I think he's not releasing it for a reason that's both obvious and alarming, it seems to me. And that is because his refusal to release it underscores how ridiculous it is to have the evidence in a case close on Tuesday and then send the jury home until the following Tuesday to marinate for a week in the publicity. And what he would say to anyone who made that argument is that, no, I've instructed them. They're not to look at publicity in connection with the case. If he didn't think that was an illusory instruction, he would just release the jury charge. But he knows that when he releases the jury charge, it's going to generate a great deal of commentary and controversy about what's gone on in this case. As we know, because we've tracked this so closely, Alvin Bragg, the district attorney, elected Democrat in Manhattan, has been very cagey from the very beginning. He didn't want to put the so-called other crime that elevates this into a felony in the indictment. The judge hasn't made him do that. He's been cagey to this day about planting his feet about what the theory is. And he's still allowed to be cagey. And the judge is helping him. So if they put the charge out, we're all going to know what he's finally going to have to plant his feet and say, this is the other crime.
Is he? Is he going to have to plant his feet and tell us what the other crime is? Welcome back Inside the Law. I'm your host, Philip Holloway. We've got a lot of stuff going on today in the show, and I'm very, very happy to see everyone here, and I hope you're having a great Memorial Day weekend. Please make sure you find some time to spend with your friends and family and remember what Memorial Day is all about. All right, so to set this first part up, we've finished all of the evidence in the Trump trial in Manhattan, where he's charged with essentially business record fraud. And at the end of the week, last week, we had what's called the charge conference. Now, that's where the lawyers and the judge get together, either in the same room, or sometimes it's done partially in the same room and then followed up by email or whatever. But nevertheless, it's where the lawyers for both sides and the court confer about what instructions the judge will give to the jury when they go back to deliberate. And if I've ever said that the most important part of any trial is jury selection, well, disregard that, because I'm convinced that now, as particularly in this case, the most important part of the trial is going to be what the jury charges are going to be. Because, as you heard me say, and Andy McCarthy in that clip from Friday with Megyn Kelly, we're going into this and nobody has really defined exactly what Donald Trump is charged with. And so we don't really have a good definition of what exactly they're going to have to determine if they're going to determine that any crime has been committed. So let me see if I can put this in the simplest of terms for you. If you're charged with, let's just say it's a theft, then the judge will have to go through what we call the elements of the offense, that you took somebody else's property and that you took it with the intent to permanently deprive them of their property. It's pretty straightforward stuff. Well, in this Trump case, one of the things that this jury has to do in order to convict him, in other words, one of the elements is that he did this bookkeeping fraud with the intention of hiding some, quote, other crime. And we've talked before about the indictment not putting him on notice. And now we're at the situation where you heard Andy say in that clip, the judge is finally going to have to pick one. Well, guess what? He didn't. Take a look at this. To convict Trump of felonies, the jury does not need to unanimously agree on what predicate crime he committed. To find Trump guilty of felony level falsification of business documents, in order to commit or conceal a separate crime, but the jurors do not all have to agree on what that separate crime was, Judge Juan Merchan ruled. The defense argued that to issue a felony level conviction, all jurors should be required to agree on the predicate crime. As it just so happens, Letitia James agrees. This is from her. She's got this on the web right now. It's from 2019, but she led this coalition of attorneys general urging that all criminal verdicts in felonies must be unanimous in state felony trials. The Constitution of the United States says that applies in federal cases, and it is the law in the state of New York. And even Letitia James is encouraging that it be the case nationwide. So we have a very interesting situation here where Judge Merchan is not going to require the jurors to unanimously agree on what the, quote, other crime is. So you basically could have, say, 4 jurors thinking that it's crime A, and another 4 jurors thinking it's crime B, and another 4 crime C. And they don't all have to agree on essentially what the elements of the offense are. I cannot begin to stress how bizarro world this really is. This is absolutely insane. Got one thing I want to try to share with you here. The Justice Department, the United States Department of Justice, also agrees. Okay, so this is from the Archives, U.S. Department of Justice, the requirement of specificity. Specificity and unanimity, they're very closely related in this context. And let me see if I can help you understand what I mean. So I've highlighted what I think is important here. The specificity requirement serves to ensure that a defendant only has to answer to charges actually brought by the grand jury and not a prosecutor's interpretation of the charges, that the defendant is apprised of the charge against him in order to permit preparation of his defense. So this is the same thing, really, of the Fifth Amendment due process requirement of putting a defendant on notice with specificity of exactly what he or she is accused of so that he can defend against it. This is exactly the opposite of what we see going on right now in this Trump trial. And the fact that people with actual law degrees are allowing this to happen absolutely blows my mind. It's just absolute insanity. And to follow that up, I want to share with you also, let's see, I have a case that I pulled that was actually cited by the Justice Department. Here it is. We have the Nance case. Let's go ahead and add that. All right, so here we have the United States versus Nance, and I'm not going to read all of this to you. I mean, it's old. It goes back to 1976. I'm older than that, so I guess I shouldn't say that's that old, but nevertheless, this is all still very much the state of the law. And in this case, it involved a federal case involving wire fraud. Okay, so essentially, count 1, the court said was okay because it was specific enough, but the remaining 10 counts charging the appellants, that's the defendants, with obtaining something of value by false pretenses with the intent to defraud, those were invalid because they go on to say that none of the remaining counts allege any of the factual particulars of the false representations which defrauded the victims. So the elements are right here in Part A. It says, whoever by any false pretense with intent to defraud obtains from any person any service or anything of value shall, if the value of the property or the sum of the money, is $100 or more, be imprisoned by not less than 1 year, no more than 3 years. So those are the elements. It's pretty straightforward. But in order to charge someone with that, you've got to be more specific. You've got to say what type of false pretense they used. Okay. So it's not enough to just track the language of the statute. You've got to be specific and say how the person intended to defraud. How is that relevant to the Trump case? Well, it's the same thing that we've got going. Okay. Because here, as in the Nance case, the government contended that the indictment is in the words of the statute. That's the same thing that the Trump lawyers argued in the Trump case. They said, Judge, we don't have to prove what the other crime is. All we've got to do is allege in our indictment that it's another crime. And that is sufficient. And it's not. The Court of Appeals goes on to say here that the following the generic wording of a statute is not necessarily sufficient, where guilt depends so crucially on a specific identification of fact. Our cases have uniformly held that an indictment must do more than simply repeat the language of the criminal statute. And they go on to say, undoubtedly, the language of the statute can be used, but it must be accompanied with such a statement of facts and circumstances as will inform the accused of the specific offense with which he is charged. They go on to say these basic principles of, here's one of my favorite phrases, fundamental fairness, that is Fifth Amendment due process. Fundamental fairness retain their full validity under modern concepts of pleading. So how you charge the defendant in a case, you have to be specific, but you also have to, that specificity has to carry through to the jury charges. And it's not enough. It's not good enough for the judge to just say, well, hell, you just go figure it out. We'll just give it all to the jury. And you just, pick a crime, any crime, whatever you want to say this other crime is, that should be sufficient. And it's absolutely not. It's absolute nonsense. And this, let me share this with you as well. Let me get my picture out of the way. I pulled this from Alvin Bragg's website. Alvin Bragg's website. He talks about the jury charge. The court then instructs the jury on the law and explains legal concepts such as the presumption of innocence, the burden of proof, and the elements of each crime charged. And that's what we just talked about, was charging on the elements of the crime. Here, one of the elements of the crime that Donald Trump is charged with is that he did these things in order to perpetrate some other crime, and they've got to specify what that other crime is. They haven't done it. They won't do it. They're leaving it up to the jury to figure it out on their own. Then he goes on to say, after the judge's instructions, the assistant DA and the defense attorney are given the opportunity to ask for additional instructions or object to the legal instructions already given. Well, that's the process we just went through. Donald Trump's team objected vociferously. That they argued that, no, Judge, they got to pick a crime and the jury has to be unanimous. And of course, the judge says, no, it doesn't have to be unanimous. But he goes on to accurately state on his website, jury deliberations begin after the judge's instructions and may last any length of time. During deliberation, the jury may ask to review evidence or have testimony reread. The jury may find the defendant guilty, not guilty, or may be unable to agree. A jury that cannot reach a unanimous verdict is called a hung jury. Okay, so even Alvin Bragg on his website talks about the jury needing to be unanimous. Judge Merchan, they do not need to unanimously agree on what predicate crime he committed. Alvin Bragg, jury's got to be unanimous. Letitia James, they've got to be unanimous. Judge Mershon, they don't have to be unanimous. It's unbelievable. Absolutely unbelievable. All right. Want to check in on the chat here. I see we have now 611 people. Welcome to Inside the Law. In case you missed the very beginning, I am your host, Philip Holloway. Happy Memorial Day. And I wanted to go ahead and welcome to the show at this time our friend, attorney Rachel Kaufman, who has, you may remember, Rachel, we've talked a lot about the Fulton County Follies and all the nonsense that's going on in Fulton County. Rachel, good afternoon.
Hi, happy Sunday.
Happy Sunday to you. Thanks so much for coming in. Rachel, I've just been talking for about 15 minutes straight about the issue of, specificity in a charging document and how juries need to be charged as to each of the elements of the offense. And I know you and I have been texting and chatting some over the last couple of days, both scratching our head in disbelief. What is your take on what's going on with Mershon and this nonsense about letting the jury just figure out what the so-called other crime is?
Well, as you were talking, I've not been following his trial in New York as closely as you have. However, what it kind of tells me, what it reminds me of, is the idea that the prosecutors don't have to prove motive. So, that's kind of what they're kind of confusing an element of the crime with the reason why the crime is being committed. I understand that they don't have to prove motive, but you should have to prove the predicate crime that he intended to commit.
Yeah. Well, I mean, so it's like when they did the charging conference, they had they were discussing 3 or 4 different potential ones that could be supported by what the prosecutor said the evidence was in the case. And the jury said, and the judge said, well, no, I don't think that one, but I'll let him pick from among these other 3. So basically they get to pick, for themselves what the other crime is. So you could literally have a jury that, some of them believe that it's one certain crime and another one, some believe it's a second one or a third. And they really have no guidance when they go back into the jury room. And to me, the concept of having a jury charge that is this, it's just bananas. I can't adequately, there's not a word that my brain is able to come up with right now to describe how insane this is.
Yeah, well, I'm just thinking about when they're back there, we don't know what happens in jury deliberations. We don't even know if they even refer back to the jury instructions. I mean, sometimes they're just read verbally and then the judge doesn't give them a copy, or they just give one person a copy. There's all that, but by saying that there doesn't have to be a unanimous decision as to what underlying crime he was trying to commit, that's really going to limit deliberations in a way that could result in somebody who shouldn't be convicted of something being convicted of something. We were having a little Twitter conversation earlier. I don't know if you saw, Phil, somebody was getting a little upset with me. About my, whether I'm not political. I don't care. All I care about is fairness. It's not political. I wouldn't want anybody charged with a crime for which their attorney couldn't prepare a defense for. It's just, they're making it very difficult. And that's what they do for everybody. So that's why I take issue with it, is that to just basically, there's a proof beyond a reasonable doubt is the standard for a reason, because we take away people's life and liberty when we convict people of crimes. There has to be proof of each element beyond a reasonable doubt. That's basic.
Well, I mean, to me, so if you're gonna say this is a felony because there's this other underlying predicate offense for which the primary offense was, committed for the purpose of furthering this, whatever second or other crime is, then a definition of the other crime is one of the elements that must be proven by the prosecutor beyond a reasonable doubt. And that's one of the elements of the crime that the judge should instruct the jury on. What am I missing?
I don't know. I mean, I'm confused. I'm wondering if there's going to be questions. I'm sure there will be. I'm not wondering. There will be questions from the jury to the judge, probably asking, is this a crime? If we don't.
Yeah, there's going to be questions. And you know what? He's going to keep saying to them, he's going to say, all right, he's going to answer the questions probably in some ridiculous way. And then he's going to go back and say, all right, keep deliberating. They'll come back. Judge, we're stuck. We can't make up our mind. We don't have unanimity or whatever. And then he'll say, keep working. And he's going to make them keep going till finally they'll just throw their hands up and say, to hell with it. He must be guilty of one of these other crimes. Even though we can't agree on it, we'll just go ahead and convict him and call it a day.
That's what happens usually.
I mean, there's going to be confusion. I'm certain of that. There's going to be questions, lots of them. We've got questions. And by the way, we still haven't seen any written documents yet, so that we, the general public, those of us who are either the lay observers or people like us who are trained in the law, none of us have had the ability yet to see just what exactly the charge is, but we do have a description, and we know at least this much, is that the judge is not going to require unanimity. All right. 809 people, welcome. Please all hit the like button. And if you haven't subscribed, please go ahead and subscribe. And if you want to support the channel, super chats are always appreciated. There is of course links in the description to the video. Thank you for supporting this channel. And that's the kind of thing that helps us bring additional content. There's some great questions, by the way, and I encourage everybody to ask questions. And this makes it easy. You see, Transplanted Texan prefaces it with question, and it helps me see it. Okay. So the question is, if the full jury believes that Trump is guilty of a crime, but they cannot come to a consensus on what that crime is, would that make them a hung jury, or what would be the remedy? Well, Transplanted Texan, my answer, and then I'll let Rachel answer it, but my answer is that ordinarily it should be a hung jury. But the way this judge is apparently going to charge the jury, he's going to tell them that they don't have to come to a consensus on what that crime is. And so in this situation, he's going to say that they're more than able to go ahead and convict him. So this is it. They do not need to unanimously agree on what the predicate crime was that was committed. Rachel, you have a different answer?
Yeah. So my answer is that in practice and in real life, we underestimate that 12 people in a room. Are there 12 people in this jury or 6?
Well, there's going to be 12. There's 18 because there's 6 alternates. So
I think it's just really, people do not like conflict. You and I choose conflict for a living, but most people don't want to be in conflict or argue with the people that they've been having to sit next to and become friendly with throughout this. To a lot of jurors, when they're together in deliberations, it's more important that they all can agree on things versus fighting. I mean, when a jury hangs, I mean, it's not as common as one might think. People like to come to conclusions. And so how often, I mean, it should be a hung jury, but usually it's just what they call splitting the baby, meaning the state wants it to be one thing. The defense is saying they're not guilty. Let's find some kind of happy medium in between, even if it's not supported by the facts, even if they haven't proved, the state hasn't proven the elements beyond a reasonable doubt, but we can all live with that. And they don't tell the jury, I mean, they don't tell the judge how they determined whether to convict or not. They just go out there with their verdict. So that happens a lot. I talk to a lot of jurors, and it's one of my, healthy deliberation is not something that most people are comfortable doing.
All right. So question, isn't there a lawyer on the jury? There's actually 2 of them. And so normally when we pick a jury, we lawyers who try cases, we normally don't want a lawyer on the jury, because what would happen, that we're afraid would happen anyway, is that the other members of the jury will simply defer to the opinion of the attorney that's in the room. And if you know any attorneys, you know that if you get 3 of them together, they're going to get 3 different answers to the same thing. So just because somebody's an attorney doesn't mean we know everything. And and that's, as I understand it, neither of these lawyers are criminal attorneys. But normally we don't want a lawyer, because you wind up having a jury of 1, but now you've got 2, right? And so I think one thing that you can count on probably is some degree of, I guess non-unanimity, because if you got 2 lawyers back there, maybe they don't see it the same way. But I think the other side of that coin is if you have a lawyer or two, as it turns out on this jury, maybe these lawyers will see this for what it is. Maybe they will know at least these basic concepts of fundamental fairness and things like specificity in the charging document, specificity in the jury, and maybe they will understand these basic things and they will be able to see that what Judge Mershon is doing is wrong. In fact, I would call it tyrannical. Rachel?
I think I'm wondering if there will be a hung jury. I think there will probably be a hung jury, which it's just kind of punting the ball. So I don't think anybody really wants to be on the jury that convicts him or acquits him. So they all kind of have an interest in hanging it. If I were in the back, I might say something of that nature. Like,
no, I mean, there are people that have said that, look, I mean, there's enormous pressure because of where this is taking place. I mean, everybody knows who's on this trial jury. I mean, if you're their office worker, their colleague, their family member, you know that this person that is on the jury. And so there's going to be enormous pressure, I think, on some. If their social circle is extremely, anti-Trump, then there's going to be social pressure to go ahead and convict. On the other hand, like you said, it might be the easiest thing might be to just go ahead and just hang it up and have a mistrial. And I've always said that we had a jurisdiction where Trump carried it by, I mean, he lost it overwhelmingly, but he got like 12% of the vote. And that was 4 years ago. And now, a lot of the people that might have been prone to vote for Trump have I think left the area in the last few years and moved to other states. And so it may be even less of a friendly place for him. But if he can get one or two or maybe three, a handful that are willing to stick it out to basically all the way through to the end, no matter how many times the judge says, go back, keep working. Yes. Spend another weekend here. All these, if they're willing to basically go the distance and hold out, I think, I think we may very well get to a hung jury.
Yeah, no, I mean, it is so hard. And this is like, you want to empower. So as a criminal defense attorney, when you know that an acquittal would have to be unanimous, you really have to empower people, and a hung jury is better than a conviction. You have to empower each person individually to use this opportunity to stand their ground based on what they've heard and seen. Like, I'm not asking them to come up with anything new, but it is very hard when the judge is sitting, especially when you're the only one. If it's split 6-6 and you've got 6 jurors on one side and 6 on the other, you've got camaraderie. But if you're just one as a holdout that really doesn't believe in it, you can hang the jury. You just have to wait out a lot of people being mad at you for wasting their time and not doing what they say. And that takes a lot of courage. So,
all right. Well, Kimmy Joe is asking, who can hold the judge accountable? I did a stream on this the other day. Go check it out. But the short answer is really no one. I mean, you got the Court of Appeals. We saw recently the Court of Appeals overturned the Harvey Weinstein conviction because the judge let in a bunch of irrelevant stuff and slimed the defendant to the point that he didn't get a fair trial. So the Court of Appeals can hold them accountable in that sense, but that's years after the fact, after somebody's either in prison or on probation. And by the way, even if he's convicted and Donald Trump doesn't go to jail, he's going to be on probation. Can you imagine being on probation and having a probation officer tell you whether or not you can leave the state, where you can travel? What's that going to do to your campaign if you're running a national campaign? And what if you win? What if you win the presidency of the United States and you're on probation? You got to answer to a probation officer.
I thought he was going to be on the campaign trail with an ankle monitor.
Well, they would have probably loved to do that if they.
I was shocked that Fani Willis's office didn't do that. They do it for everybody else. So they say that they didn't give him any special treatment. I'm not saying, and I'm somebody who wants to scale down. So just because I feel like my clients and people, the average Joe, has been mistreated in the criminal justice system, doesn't mean that I want to see somebody who I feel like has had more privilege be screwed equally. I want it to be more fair for everybody. And I hope, so to that extent, he deserves a fair shake. And just because the system's unfair for other people doesn't mean this should be unfair for him. But
All
then
right, Rachel, for those of you who have not met Rachel before, she's a very good practicing criminal attorney here in the metro Atlanta area where I am. Rachel, one of her favorite places to go, and so I think she needs to seek professional help, because one of her favorite places to go is to the Fulton County Courthouse. Rachel, how are things at the Fulton County Courthouse lately?
the escalators are now working after like 3 years of not working. So I'm impressed that they got those moving. But it is just, we've got the YSL trial going, the Young Thug trial Monday through Thursday every week on the first floor. I was in court on the Cop City RICO case recently where they had 60 plus attorneys file into one courtroom. It was
60 lawyers in one courtroom.
Yeah, it was madness. And things are just moving very slowly there. The wheels are slowly turning.
All right, we're gonna get you to bring us up to speed here in just a little bit about what else is going on in Fulton County Courthouse, particularly with the Young Thug case. But before we do that, I want to talk a little bit about Diddy.
It's so difficult to reflect on the darkest times in your life, but sometimes you got to do that. I was fucked up. I hit rock bottom, but I make no excuses. My behavior on that video is inexcusable. I take full responsibility for my actions in that video. I'm disgusted. I was disgusted then when I did it. I'm disgusted now. I went and I sought out professional help. I had to go into therapy, and go into rehab. Had to ask God for his mercy and grace. I'm so sorry. But I'm committed to be a better man each and every day. I'm not asking for forgiveness. I'm truly sorry.
There's nothing more powerful than the odor of mendacity.
All right. So, look, this I don't know about you. I have occasion to interact with people who are in therapy or some type of rehab on a very regular basis. I have occasion to interact with the providers of that therapy and those mental health and other health services. And I have not yet learned of or seen a don't beat the hell out of your girlfriend rehab facility. So I don't know exactly. Look, obviously, if he feels, we want him to get whatever help is appropriate. That's it. That goes without saying. But to me, in my opinion, this feels a little bit, I don't know, contrived. It feels a little too convenient. It feels like it's something that it's more like he's trying to rehab his public image. What's your take on that?
So, obviously that's an incredibly self-serving apology. I think it comes at a time where he's now been exposed for the things that he's previously denied that he's done. It's kind of a reckoning moment for him. I feel like an apology. I think that's all he can say. Sometimes there's nothing to say. Sometimes it's just taking the hits as they come at this point. They're going to be delayed hits since this happened so long ago. I'm always bothered when people say they're asking God for mercy. Like, ask Cassie for mercy. That's the woman that he threw on the ground. I want to say also, I've represented many people who've been in domestic violence situations, none of which have ever been caught on video. I'm someone who kind of tends to, again, give somebody the benefit of the doubt, because I feel like, as a woman, I don't know, things can get escalated. Women can fight too. Not that anybody should ever hit a woman, but I've actually never seen anything like I saw in that video with Diddy. And it sort of humbled me and quieted me, because I just couldn't believe my eyes and couldn't believe that he's been walking around pretending that didn't happen.
Was it like 2016?
Yeah, it's crazy. but I think he's claiming he had substance problems. So he's saying that he went to rehab and stuff, not for, beating the crap out of her, but for getting so screwed up that he doesn't have control over his himself, which clearly.
Well, I mean, I thought about showing the video here, but it's really not necessary. We don't need to see it. It's available elsewhere. And also, if I show it here, then this video is probably going to get demonetized, because anything of that nature is one of those things that they really don't like. So this video could get demonetized real easily if you show something like that. But
he's got bigger problems though, so he's got.
Yeah, I mean, so but here inside the law, what we do, folks, is we use things that are currently in the news, legal issues and cases that are currently in the news. We use those as the mechanism to explore and to bring you inside the real justice system. And so one of the lessons that we can take from this and we can learn about is statutes of limitation. Statutes of limitation are typically things that are, and each state is different, and they have different statutes of limitations for different offenses or types of offenses. But it stands for the idea that after some certain period of defined number of years, then it's just too late for the state to bring a prosecution. And I think this was California, if I'm not mistaken. And it's my understanding that it's well outside the statute of limitations. But the statute of limitations should have barred the Trump trial too, but we'll talk about that again some other day. The district attorney, I guess, in LA has publicly stated that he's not able to prosecute this case based on the statute of limitations, even though there's overwhelming evidence of guilt. And now we've got a public admission that we just saw. Rachel, can you help our viewers and listeners understand what is sort of the public policy behind having a statute of limitations in the first place?
So in the same way that somebody should have the right to know what they're being charged with and the specifics of it, not just something that tracks the language in the statute. You have a right to be tried within a reasonable period of time such that you're able to even build a defense. There are many exceptions to these rules. For example, if somebody has been, assaulted in a way that they didn't know who the person was for several years because there weren't DNA tests. If it's a perpetrator unknown, as they say, and the statute will toll, the statute of limitations tolls, and you can actually, 20 years down the line when you get their DNA, charge them. But
by tolling, what she means, folks, is it stops the clock from ticking. It's like calling a timeout in a football or basketball game. The clock will so-called stop ticking for a while. And there's a lot of other things that could cause it to toll. And Rachel, I think one of them here in Georgia, in some circumstances, I mean, one thing that will actually start the clock from ticking, start it ticking in the first place. And this is always, sometimes it's a bone of contention and it's a source of litigation. It's when does the clock start and has it stopped at any point? But in many places, it's when law enforcement or the government or police get sufficient knowledge of the case, whether they can prove it or not. But if the police are aware of it, that can start it. But in some instances, it's knowledge of or awareness of the crime by the victim.
Yes.
Because that victim's knowledge is what we call imputed to the state. I didn't mean to cut you off, but we were talking about legal words and I wanted to define them.
That's exactly it, is that, if there's no complaining victim and the victim knows who the perpetrator is, they can't wait several years, tell a law enforcement officer, and then they're just going to start investigating. Then it sounds like in California, there's been bills that are now in their Senate or whatever to try to, expand the statute of limitations. So it's more like 10 years. I'm not really sure. I mean, to me, that'd be tampering with evidence if he somehow bought the surveillance footage to avoid it ever being located. But if the victim, if Cassie never reached out to police about it,
I think she sued him. Didn't she sue him last year? Right. And like he settled it like the very next day. Wrote her a big check.
But then claimed that it had nothing to do with his guilt. And sometimes it has to do with having really good advisors with you. Before he makes any kind of statement like that. If I was managing him, the question is, if there were to be surveillance, can you stand by the statement? Because now he's putting his foot in his mouth. You're saying sorry now, but before she was a money grubbing, whatever you called her. Bad. Looks bad. But it can be used. Yeah, really quick. I mean, I know that there's an ongoing investigation into him for other related things, and I'm
Oh
pretty
yeah,
sure
he's got lots of open investigations, and
come up.
something tells me this is not the end of the problems for
No.
Diddy. He's got bigger fish to fry coming up. So we're going to keep watching this. Want to switch gears now. One of the reasons that we love having you here inside the law is because you follow it closely so that the rest of us don't have to follow it so closely.
Every day
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lies.
Yes, you may. We're gonna take a break soon. Hang in there.
I can't go into the YSL without playing that guy. And so before Rachel, you and I, you helped me find this earlier. I want to share with everyone. This is something I pulled this off of Twitter. It's compliments of Thugger Daily is the gentleman or lady on X that put this picture out there. But this is you don't have to read all the names, but this is like the list of witnesses, and it's approaching 150 names. It says we are here, and it's we're not even maybe halfway through. But on this list of witnesses, do we know who that witness was? He was towards the beginning, right?
Oh my gosh, I don't know. It's been so long, but
It doesn't matter. He was nevertheless, he was a state's witness. And for those of you who might be new here, welcome. We have almost 1,000 people. Welcome inside the law. Please hit the like button and subscribe. We recently, by the way, I got to brag just a minute. We passed the 30,000 subscriber mark, which was a big milestone. I'm very humbled and flattered by that achievement. And I want to thank everybody who has subscribed for helping the channel get to that point. We still need to continue to grow. That's the hope and the plan anyway. So please hit the subscribe button. It doesn't cost you a dime. And tell all your friends, tell your family, sign all your kids up, open up 15 different browsers, and but we want to make sure everybody subscribes. Thank you very much for that. And thank you for supporting the channel. Thank you for helping us get here. I really, really appreciate it. All right. So Young Thug he's a Atlanta rapper. He's being prosecuted by Fani Willis, and he's charged with, among other things, racketeering. It was a giant RICO case. It was approaching 30 defendants in the beginning, Rachel, and now it's down to a couple of dozen, or
there's 6.
Just now. Okay. So but a lot of them have either pled out, or they've cut deals, or they've been severed out for one reason. So it's still this massive giant case. And as we are learning, courts just are not able to digest cases like this. And they're now saying, maybe it was hyperbole, but one of the defense lawyers was projecting that this case might go till 2027. So what's going on down there, Rachel?
This is the shortened witness list that you just posted. So as I think I've told you, I represent somebody who was subpoenaed by the state on their witness list, but she's not on that that short list. She's still not allowed in the courtroom. So in addition to the witnesses on that list that have not gone yet, there's still probably another 100, 200 witnesses that are under subpoena that,
All right. What are they saying that Young Thug really did? I know that it's racketeering, but what is the essence of this case? What are they saying? How is he a criminal according to Fani Willis?
Basically that he's like a shot caller in a gang that commits a lot of crimes, and that he financially supported a lot of people that are accused of doing bad things. So
rather than carve out the specific offenses, she's just lumping them all together in a giant racketeering case. Is that what's going on, or do they have some more specific charges as well?
Most recently, and this is what bothered me from the beginning, a lot of the people that Young Thug grew up with don't have the money and the means to get the things that a lot of them want. He rents one of them a car, and then maybe that person uses the car to go do something that's illegal. just because he rented you the car doesn't mean that he intended whatever crime you went off and committed. It's like ridiculous. It's like somebody bought me a purse and then I put a gun in my purse. Did they intend for me to put the gun in my purse? Just
Well,
doesn't make sense. That's how far removed he is from the actual incidents.
And they're using, and this is something that's been a bone of contention with the record and the recording industry here in Atlanta, which is actually pretty big. The prosecutor, Fani Willis office, is attempting to use lyrics for these rap songs as substantive evidence of a crime. Well, I mean,
Yeah.
what exactly is there? Some smoking gun contained or some confession contained in these lyrics?
I would say no, but I would say that, these aren't lyrics that you'd want your grandparents listening to. And it does tell a story of things happening, but after they've happened.
But it's not, they're not saying in the lyrics, they're not saying these are true. It's more like, it's a fictional. I mean, maybe it's the kind of lyrics that don't make for polite dinner conversation, but should it be used as evidence of a crime?
It definitely shouldn't be used in place of actual evidence, and that's
Right.
kind of what's happening. If there's tons of other evidence to support it, that's one thing. But also, what Young Thug raps about in his music, to say that anybody in his supposed gang agrees and subscribes to whatever he said in his music is wrong too. We each have our own voice and our own brains. Like, they don't have ESP. And that's kind of what this whole case is. Just, they must all want to be bad all the time.
All right. So you sent me, you helped me pull some video, and thank you for that. You sent me something that, let me just play it, and then I'm going to get you. This is some real footage from, I guess, recently. And if you don't understand it, you will when we come back and explain it.
He didn't preserve it. The defense has put you on notice that they're objecting to that. So and you've got confrontation clause issues. These reports are made for the purposes of prosecution. They fall squarely within Crawford for that particular reason.
Actually, Judge, they said otherwise in Kamasuko, if I may. They said that.
If I can make that determination about them falling under an exception, yes. But at this point, because I can't make that determination, and I just.
And Your Honor, for CAD reports, I just point out that we normally do not have the person making the call.
Okay, and you know what? You may be able to get these in later. If you're going to have the officers testify about these particular instances, I don't know, this being 9 years ago, whether or not you're going to be able to do that. But, the defense in these particular ones has made a pretty valid objection in the court's opinion. Now.
All right. So, Rachel, before you explain what we just saw, normally when the way it works is if somebody, let's just say a prosecutor is wanting to introduce some piece of evidence or even testimony or physical evidence, a picture, a document, whatever, if the opposing side, in this case, one of the defense lawyers, objects to it, the procedure is to say, objection, Your Honor, and then you state the legal basis for the objection. For example, objection, it's not relevant. So the objection would be on the grounds of legal relevance. And so the judge ideally would turn to the party that's wanting to introduce the evidence and say, okay, how is it relevant? And then the judge will hear the arguments of both sides briefly, very briefly, and then we'll say sustained or overruled. And that's how it's, at least when I went to advocacy training, that's how I was taught it was supposed to happen. But that's not what we saw. Rachel, what are we seeing here?
What we're seeing here is actually, like, outside the presence of the jury, I believe, we have a ruling that the judge is prepared to issue on the record regarding a hearsay objection made by several defendants. He is planning on sustaining that objection and not allowing the state to bring in certain documents through the witness that they were trying to bring them in for, instead of simply saying they're excluded or I'm sustaining their objection. And for some reason, Adrienne Love is standing at the podium like it's her courtroom, And the judge is kind of he's apologizing and explaining why he has to rule against her. And she's arguing with him. She's interrupting him. You've got a defense attorney in the background objecting. The judge is ignoring that defense attorney and just allowing. She's like, if I may. It's like, you may not. See, that's what I would just say. You may not, Adrian. You may not. You need to be quiet and sit down. And
that's Adrian Love. That's the prosecutor. That's who we saw in the video, right? And so, the way I see it, she's just making this. She's dragging it out. We got a jury that's already been there. They've had their life basically turned upside down. They can't maintain a job. They can't run a business. They're basically being held hostage for years and years and years because Fani Willis and her prosecution team have made this case just so ginormous that it can't be adequately, processed by the courts. And then we see the ADA Love. We see her there just quibbling over. And to me, that's just unnecessarily dragging it out.
I mean, yeah. And as a defense attorney, I just don't want to be here. If the judge wants to entertain ADA Love and all of her legal thoughts and opinions, do it somewhere other than the courtroom. Nobody wants to be here for this. I would be so mad if I were on that trial, and there's no way I'd be able to sit there and take any of that with her. I find it to be exhausting when we're just talking. Just sustain it. Let's move on. I'd be beeping.
Senior Chief comments here that the judge appears to be afraid of ADA Love and Fani Willis. I don't know that I know either. Do you have a sense of whether or not that could be the case, Rachel?
I don't. He has nothing to be afraid of. I'm not sure what's going on. I've tried other cases in front of him. I was actually just saying to my boyfriend earlier today, I feel like if I was on this case, there's just no way that this would be happening, because the judge and I have a dynamic where I feel like he trusts me. He's not nice to Matt. He does not seem to be very kind or appreciative of Max Shard's opinion, and he's a very vocal defense attorney. The judge, if I'm looking at the judge in the eye and saying she's being completely unethical and she's lying, I just can't imagine him continuing to engage with her this way. But as it is, we're going to be here forever. They're going to be there forever listening to Adrian explain away why evidence that should be excluded should somehow be allowed in.
All right. Frank says the bailiff has actually had to tell Miss Love to sit down and be quiet.
I wish I had that privilege.
You want to tell her to sit down and be quiet, or you want to be a bailiff?
Both. I'd like to be. Yeah, I want her to listen to me and sit down.
Right. Well, I don't know that I've seen that. I would love to see it, but I tell you what we have seen. We have seen this. All right, that is Young Thug asleep in court. It's almost like, look at the. It's almost like they're just sneaking by him. They don't want to disturb him. I assume that was at a time when the judge was not on the bench, right?
No, the judge was on the bench. The judge was on the bench. It was like a few of the attorneys had approached the bench to discuss things. So that's Young Thug protecting his peace.
Protecting his what?
His peace.
Oh,
he was taking a moment. He was taking a moment.
Inner peace. Okay.
His inner peace. Yeah, he's just taking himself somewhere else. I would be doing that as often as I could to avoid making horrible faces that I'd want to make every time the prosecutors spoke. But yeah, that's how boring it is. It moves so slow, and I would fall asleep too.
Well, look, you got I mentioned the jurors being held hostage. And obviously they get paid. It's $25 a day. So they're being well compensated for their civic duty. But look, these people need to get back to their lives. This is one of the things that's frustrated me to no end about the Trump case being off every Wednesday. So you got Monday, Tuesday, and then Thursday, Friday. And then off again for the weekends. It's just crazy how these judges, I guess, extend things like this to the point that it's, it just drags it out in my view, just needlessly. So he takes these extended, comfort breaks all the time. You have lots of things that take place outside the presence of the jury. he's threatening to make them work weekends, yet he's giving them every Friday off. And so now it looks like it's going to drag on and on. This case is not going to be finished this year. It may not go to 2027, but it's not going to be finished in 2024. So I think it's going to go at least into 25. But do you have a sense for, why we're only having court 4 days a week?
No, I don't. I know that Judge Glanville's like the chief judge of the Superior Court of Fulton County, but I don't know what actually transpires on Fridays. But obviously, every day that the jury is not in court hearing evidence is a day that they could be discussing the evidence and reviewing news stories and doing things that they've been instructed not to do, not because they're bad, but because they're human. And this is taking so long. I also think what's been very interesting, we're still in the early 2010s in the YSL case. A lot of the defendants' attorneys are not even participating in cross-examination. So I'm just waiting. So I'm just waiting till the point where at the end, some jurors are probably going to be like, who's this guy?
Our Deputy Chief Assistant Chat Boss Kiana Shaw says the judge says he has an appointment every other Friday. Which makes sense. I mean, and I get it. You want to accommodate not just the judge, but lawyers are going to have circumstances where they need to have a day off here and there. We're coming up on graduation season. Even they let Donald Trump, off for his son's graduation, and but now we're getting into summer vacation. We got kids out of school, and I just it just seems to me that we need to be able to just go ahead and wrap this up. Is there anything, Rachel, that you can think of that courts or the legislature could do to make sure that when a prosecutor brings a trial or brings a charge like this, that it's something that's manageable, that it's of a size that can easily be sort of bitten off and digested by the courts? Other than just, trusting prosecutors to do that, is there anything that we can do legislatively to maybe keep this from happening?
I don't know about legislatively, but I believe the judges have the discretion. I'm interested in what kind of laws could be, enacted, but I do feel like a judge has the discretion to control the pace of trial and to move things along. I'm sure you've had many times where a judge has said, move along, Mr. Holloway. And you just say, okay, judge.
I've never, ever had a judge admonish me for, no, of course I have.
That's exactly. So you move on. You don't just keep going. The judge could easily control it. In this Cop City case, we're still in the early stages. However, Judge Kimberly Esmond Adams, who's also on the Fulton County Superior Court bench, definitely wants to make her the process by which she handles this. I think there's 60 plus co-defendants, how she plans on organizing the case such that it is digestible. There's 150 motions, defendants are joining each motion. It's been a mess so far. I wish
it's their job though, but part of their job is to be an obstructionist. I mean, the defense lawyers, look, they can't be blamed because it's in their interest, at least in their client's interest, maybe not their own personal interest, especially if they're trying to keep their law practice afloat financially, but it's in their client's interest to delay this verdict for as long as possible and to obstruct the prosecutor at every turn. Eclectic Deb points out repealing RICO, whether it be repealed or whether it be changed and modified in some way, that's a possibility. Of course, the legislature would have to look at that. Gene points out that he says he does veterans court, which is an accountability court. A lot of jurisdictions have these. And of course, it's very, very important. By the way, if you're a veteran, thank you for your service here on Memorial Day weekend or active duty. Same to you. Thank you for your service. But speaking of veterans court, there's other judges that could do veterans court. Okay, so it doesn't have to be Glanville that does it. Maybe he likes it. I get it. If that's what, if he wants to do it, but these jurors want to get back to their lives too. No, I think
it's also the prosecutors. It's also the prosecutor's responsibility to indict or charge a case in a manner that a court can actually handle it and that the defendants can get a fair trial. That should be part of the way in which they charge cases. I don't know.
Well, speaking of charging cases, Jason Hodges points out what's Fani's deal with these RICO cases. The first one that I remember that she was involved with was the Atlanta Public Schools cheating case, which was a big giant racketeering case. She was not the DA. She was an assistant district attorney, worked for Paul Howard, her predecessor. But she, she indicted I guess dozens, I forget how many, school teachers for allegedly cheating. Well, I guess they were convicted on standardized testing. And so fast forward to today, she pulled the trigger on this Young Thug giant racketeering case. And then she, of course, did the Trump racketeering case. We're going to get to a Fani Willis update for the appeal here in just a minute. But it seems to me, Rachel, that she learned years ago that she likes racketeering. She likes RICO. And I think one of the reasons for that is because she's able to bring in so much extraneous conduct, if you will, that might not otherwise be relevant in a more traditional prosecution.
Correct.
That's just my theory.
I think it is. It's the most unfair way to prosecute someone. It's the most excessive way to prosecute a group of people, to avoid them getting individualized consideration. And it's a great way to expand power. I mean, we think about how much money has been allotted to these RICO cases. And she gets to expand her office and power the more cases that there are. Kinsey
apparently is one of our smartest chatters today because she agrees completely with me. Oh, and by the way, I'm being facetious. If you disagree with me or you disagree with Rachel, put what you have to say in the chat and the comments. And if we don't talk about it on the show, I like to go back. I will rewatch these videos and I will look to see what was in the chat when these shows are live, because I want to see the feedback, whether it's good or bad or neutral or whatever. So feel free to chime in. This is a free speech zone here. You can say, with very few except, you can let us know what you think about the content. And by the way, if you like the content, it's 1,000 people, hit that like button for me. It helps other people find the channel. Also, there are links in the show description if you want to support Inside the Law, and which will help us to continue to bring this content and additional content moving forward. Rachel, we've been at it an hour. By the way, Kiana points out that she likes RICO because it allows seizure of funds. Yes, it does, but there are other ways to seize money. I think she likes it because it makes her job easier in a way. It's ironic that by making it easier, you make it last 2 or 3 years. But anyway, dear woke Christian, I thank you, by the way, for the let me pull that up. Dear Woke Christian's got a great channel, and he's also my neighbor. He apparently is right down the street from me, and we are going to get together. We're going to find a time to do something together in the near future. Thank you, by the way, for the super chat, and obviously everybody check out that channel. It's a great one as well. Thanks for coming by here. I want to talk before we go about Fani Willis, in particular, the disqualification. You've been following the machinations of that saga, Rachel?
Oh, yes. I think we've gotten the briefs filed, right? Or is the state are we still waiting on the states?
Yeah, well, we're at the point now where the parties are filing their appellate briefs, and the state, I think, responds. But, there were, I think, 4 or 5 counts that got dismissed by Judge McAfee that pertain to Trump and 1 or 2 of the others. And I apologize for not having all of this memorized and on the top of my head, but look, this is so crazy and so complicated. You need to have like a whiteboard and a diagram to keep it all straight. But I know that a number of counts were dismissed. At first, she was not going to appeal the dismissal of those.
I want to answer that after.
Yeah, but now she is, and the reason because the Court of Appeals is going to be taking up the issue of her disqualification. She's going to appeal that, so that makes sense. But we have yet to see the appeals briefs by the parties, and once we get all of those, and by the way, we're going to be able to bring you those here Inside the Law and go through them and with a fine-tooth comb, maybe line by line, or certainly piece by piece and talk to you about what they mean and what they're saying. But then after the defendants file their briefs, the state gets to file their response. And then we hear oral argument. When are you hearing, Rachel, about when that might be?
My understanding was it was possibly going to be late summer. I think that's what Ashley Merchant had told us, maybe August.
Yeah, I think it's going to be. Earlier I had said it might be July or August. I think that based on the way the timing, it's going to be at least August. And I want to say they have until March of next year, if I'm not mistaken, to issue the ruling. I don't think it's going to take that long. I think we're going to get a ruling on the Fani Willis disqualification issue. My prediction is October. What do you say?
I think that's hopeful. I mean, I'm hopeful. October, November, hopefully into the new year, things will be worked out. I also know, I think I told you that we can kind of talk about the election. So Judge McAfee won his election. And I expect several rulings to now come out in the next.
Were you surprised by that? I
No.
kind of was. Actually.
No. I knew that the other guy wasn't really campaigning that much. And you know, Fani didn't have, for Fani, who also won her primary, but it's just the election because she won by more than 50%. There's just really nobody that was qualified
Well, there's a lot to be said for having the word incumbent under your name on the ballot. Because, you know, if you're like me, on these, the judges, by the way, in Georgia, they run in what we call a nonpartisan primary. They may be hyper-partisan, but they all go together on a nonpartisan ballot. So you don't run for judge as a Democrat or Republican or whatever. District attorney you do, but not for judges. And so they're all in the same primary. It's in May, and we just had it last week. And so I get these text messages or phone calls, people that maybe I hadn't heard from in months and months and months. They'll text me and they'll say, who should I vote for judge? Do you get those? Because nobody knows. The judges are like, they don't know who to vote for. Do you get that?
Yeah, more often than that, I get the candidates calling me and asking for money. And I tell them that I only give money to animal causes. But, you know, yeah, these political races get locally heated, but yeah, many people are just completely unaware of what the difference would be. I couldn't really speak on Mr. Patillo, but I could speak on Judge McAfee. I think he's moderate enough. I think his rulings are moderate enough that he didn't offend the liberal people, and he may have offended many conservatives, but not that much.
He's got a better judicial temperament than I would. I would have lots less patience for some of this. The only thing I'll say, and this is not really criticism, it's more of an observation of Judge McAfee, is that he lets people get like Fani, for example, with the way that she stormed in that courtroom and she was just trying to take it over. I don't think I could have tolerated that.
No,
he was very patient.
Stunned. I think he was stunned. The more I think about it, I just think that that was so unexpected that like he just was sort of frozen in space. I mean, and I don't know if he's ever interacted with her as a judge, with her as a litigant. I mean, that was really the first time she's been in there involved in that. But yeah, so I'll be very interested to see what orders come out on some of the motions that have been pending before Judge McAfee, because, you know, we talked about while this is on interlocutory appeal, is he going to continue to allow the case to, you know, move forward and litigate it? And his answer was yes. And so I expect that. I do expect that to happen soon.
All right, Rachel, thank you very much for joining us here inside the law. Hope you do something fun the rest of your Sunday and enjoy your day off tomorrow. So we're going to say goodbye to Rachel before we wrap it up. Everybody wave goodbye. Big round of applause for Rachel. All right. Thanks again, everybody. And it is Memorial Day. Make sure you find a veteran or an active duty person and make it a point to say thank you for their service, because without them, none of us would have the rights to. This is, you know, we're engaging in free speech and freedom of association right now in what we're doing. And those are the rights that are protected and secured by the men and women who have fought and then even died for our country. So make sure you thank a veteran. Hit the like and subscribe button for me. And I want to say, this is a personal note, thank you all very much. I cannot overstate how grateful I am for helping us here inside the law to hit the 30,000 subscriber mark, because it's very, very humbling and flattering. And what it tells me is that there are people who, you know, have a intellectual curiosity. They want to learn about the real justice system. They want to learn about what actually happens in real courtrooms across America every day. And that's what we try to do here. We want to bring you inside the real justice system, use cases that are in the news. It's not always going to be Donald Trump or Fani Willis. There are other things out there on the horizon. I'm already looking at things, but in every case, criminal cases particularly, that are in the news, there's lots that we can learn from them about how the real justice system works. So with that being said, thank you all very much, and we will see you back here next time inside the law.